All right. Good morning, everyone. Today is Friday, February 25th, 2022. We are, how many lists do we have? These are what, fourth voting lists?
This is our sixth.
Sixth voting list, holy cow. Halfway through, today's the halfway point.
Nope, tomorrow is.
Tomorrow's the halfway point, sorry. All right. So we'll start off with Senate Bill 33. There has been an amendment attached. There was a motion for a favorable. It has been seconded. Do we need to record a vote? Is everyone okay? Everyone's good. Excellent. Great. We'll now move on to Senate Bill 547. There's a motion for an unfavorable withdrawn. Everyone's okay? Great. All right.
That's like the first 1, 2, 3, 4,
Yep.
5 bills.
Yeah. 547. All right. So the motion is then to take 609, 615, 619, 850, all of which have been withdrawn. So the motion's for unfavorable withdrawn on all of those bills.
Second.
It's been seconded. Everyone's okay? Great. Next bill up is Senate Bill, hold on. Is counsel here yet? He's not.
No.
Okay. So, Senator Sinner, just because we're waiting for counsel to get here, so as soon as he gets here, we'll hit that. Let's start off then with Senate Bill 377.
Name change.
So Senate Bill 377, this bill establishes procedures for the issuance of a new marriage record when the name of a party to the marriage has been changed. There are no amendments.
You're on mic.
All right. Senator Lee. For favorable, it's been seconded. Everyone okay? All right, so with Senator Cassidy is no. Everyone else is okay? Okay. Senate Bill 377 passes. Okay, we'll now go to Senate Bill 357.
So there is an amendment in your packet. So the amendment is the sponsor's amendment. It is the same as the amendment that is proposed in the House. The House bill has not moved yet, though. So what this amendment does is it strikes the entirety of the bill except for the work group. It does add an additional member to the work group. And I have hand-marked a technical change just as a conforming change. And it also changes the date for the report to be issued. It bumps it back.
All right, is everyone okay adopting the amendment? Excellent. All right, further discussion. All right, motions for favorable as amended.
Second.
It's been seconded. Everyone's okay? All right, the bill passes with the amendment. Good old Senator Benson. All right, let's go to 431. Josh. I saw Weston Wall Strikers, my apologies. So, all right, we'll go to 4. I'm sorry.
Add Senator Jackson to Senate Bill 357
As an amendment?
as a co-sponsor.
Sure. Yeah. Senator Lee also wants in. So we're going to go to 435. It's a West bill. We should hold all of them because we're going to hold. Yeah.
This bill establishes that an individual who intentionally prevents or interferes with the making of a report of suspected child abuse of a child by a mandatory reporter may be prosecuted at any time for the violation. So this is currently a misdemeanor with a maximum penalty of 5 years and/or a $10,000 fine.
So I think we've passed this twice before.
What's the,
It was unanimous in JPR and on the Senate floor last year.
What's the, is there a statute for the underlying report? Is there a statute of limitations for the report to be filed?
I don't know the answer to that.
I don't know why we would extend that longer than the actual limitations period for the.
Because what you're doing is that, because you can go back, like, let's say whether it was a church or any one of these organizations, like Penn State or whatever, and you find out 5, 6, 10 years later, like Penn State's a perfect example, that's why we did the law, that they were actively you find out Penn State, they were actively covering up and preventing the reporting of abuse. Like, you actually had coaches that witnessed it, and they said, no, don't report it, don't say anything. You didn't see anything. So then you could go back now, after the 3-year statute of limitations, you could charge people who, but you have to, it's not on mandatory reporting, it's on the part of the law that you prevented or obstructed someone from doing the report.
So so it doesn't matter whether they want to file, whether anybody wants to file a report? It doesn't matter?
It doesn't change if you failed as a mandatory reporter. This is only the aspect that you actively stopped or prevented a mandatory reporter from making their report. So that's the only part of the crime that we're getting rid of the statute of limitations, because that's more of an organizational type crime. So if you had a church and somebody in the higher up church was, this stuff happens unfortunately all the time.
But as I have never been in favor of ending the statute of limitations for those reports of child sex abuse, I don't know that I'm.
Well, that's a civil though. This is criminal. Remember the criminal,
There's no statute, okay, there's no
yeah,
statute.
there's no
there.
statute on the criminal
Okay,
side
okay,
either.
You're right, no statute.
Yeah.
Oh, so for a felony sexual offense, there's no statute of limitations. So for a misdemeanor offense, not for child though, it's 1 year from the event. So when the individual's making the filing of a report, at that time, there's been no determination if it's a felony or a misdemeanor.
Yeah, this applies to the person that's required to report according to law or statute.
Yes, mandatory reporters are required to file a report.
Order, right?
Yes, if an
This
individual
bill here.
interferes with a mandatory reporter making, filing a
And
report,
there's no statute of limitations for that,
it would remove the
for
statutory,
that person being charged, the reporter who's supposed to make the report, right?
for the individual interfering with the
Oh,
reporter.
interfering, right, okay. Okay, thanks.
It's been seconded. Is everyone okay? All right, bill passes. We'll now go on to Senate Bill 439. And then Heather, we're just going to continue on. We'll do actually, I'll do those last. So after this, 439, Josh will pick up with Senate Bill 447. Okay.
So Senate Bill 439, this bill increases the salaries and travel expenses of specified public officials in Somerset County, for example, sheriffs, state's attorney, county commissioners. So it increases the salary beginning the next term of office. There are no amendments in your packet. So for example, the sheriff of Somerset County receives an annual salary under current law of $75,000. Under the proposed bill, it would be an increase of $10,000 to $85,000. The state's attorney's salary is currently stated in code. This bill proposes to make a change that's similar to other counties, which ties it to the salary of a judge of the district court. So it's 80% of that, and then changes continue throughout the bill.
Second. All right, everyone okay? Senate Bill 439 passes. All right, we'll now move on to Josh with Senate Bill 447.
Senate Bill 447 prohibits the use or maintenance of an improper or outdated address in documents filed with the State Department of Assessments and Taxation. The bill authorizes an owner of a property to file an affidavit with the department stating that the address is being used in violation of the bill. And the bill also establishes procedures for settling and resolving disputes concerning the use of addresses.
Favorable, unless there's further discussion. Sure.
Can you, it's a, may not use or maintain an improper outdoor address. I take it that's on like on government websites, that's what that's hitting at?
Yeah, so this is to essentially expunge a bad address from ESTA.
Well, it puts the burden on the company owner to do that, right? Or is it burden on SDAT, it's the company?
So it puts the burden on the new address holder to indicate that an old address is no longer correct. They then contact SDAT. SDAT then attempts to contact the old address holder. And if the old address holder does not respond saying, this is in fact my address, then SDAT has the ability to remove the bad address. If the address is contested, in other words, if the old address holder says, no, this is still my correct address, then SDAT cannot expunge it, because then you have a conflict between the new address holder and the old address holder, and SDAT doesn't want to arbitrate that. Then the two parties can just go to court and say, this is my address, this is my, or not my address.
So, I'm just, what kicks us into gear? I mean, who would go to SDAT and say there's a bad address?
So in the case of, so this came from a constituent. So this constituent purchased a home that had been previously used as a business. That business owed a lot of bad people a lot of money. And people were coming to her door saying, you owe me this money. And a police officer came to her door armed and said, hey, you know.
Gotcha, so she could notify SDAT and say the business isn't here,
Correct.
and then SDAT would reach out
To the registered business and say, hey, someone says this is
Gotcha.
not your correct address.
Okay.
And they can either not reply.
Right.
They can agree, or they can disagree.
Okay, so it's complaint initiated.
Correct.
Okay, I'm
Yep.
fine with it, thank you. All right.
I'm been a motion for favorable, it's been seconded. Is everyone okay? All right. Senate Bill 447 passes. We'll go on to, Josh, we'll stay with you for a little bit. Let's go on to 559.
Senate Bill 559 authorizes the use of supported decision-making, establishes a process for entering a supported decision-making agreement, and the effect of an agreement, outlines the role of a supporter, establishes certain immunities for third parties acting in conformity with an agreement, and makes some related changes to the definitions of incapable of making an informed decision under the Healthcare Decisions Act. Just for context, a supported decision-making agreement would be an agreement between someone who's disabled or otherwise incapable of making their own decisions and various third parties who would be authorized to assist them in that decision-making process. There is an amendment in your packet. It's number 333421/1. It does several things. It specifies that an agreement does not supplant the authority of a power of attorney or advance directive. It requires supporters to deliver a copy of an agreement to a guardian of the person or an individual who has a power of attorney or advance directive. It removes an authorization for a person to authorize a supporter to enforce their decisions without their presence. It adds someone the adult has obtained a protective order against to the list of people who cannot be supporters. It adds certain written elements to the agreement. It requires agreements to be signed, and it makes some changes to the immunity provisions. There's also a couple of technical amendments that need to be made. If you're looking at your reprint, we would additionally, in the purpose paragraph on page 1 in line 6, instead of saying authorizing an adult to enter into a supported decision-making agreement, the bill would instead say recognizing the right of an adult to enter into an agreement. And then on page pages 5 and the page after page 7, there would simply be a technical change to the language. So instead of referring to a trustee of a revocable trust agreement, it would simply say a trustee under a revocable trust agreement, which is more consistent with the way that term is used elsewhere in the code.
Mr. Chairman, so I guess, can I ask the bill sponsor, there were folks from the Bar Association who were concerned. Have everybody's concerns been allayed here?
They have, yes. These amendments are the work product of a lot of time that's been put in between the Bar Association and the advocates. And this is the work product of that, so everyone is good.
Thank you.
Hospital Association was only in on info only. I take it they're now supporting as well, or?
I don't know about, the answer is I don't know about the Hospital Association.
Okay.
I do not know.
Are you talking about the Health Facilities Association or the Hospital Association?
They're still not.
My understanding is that the health facilities folks are okay now.
They are now?
Yeah.
Okay. It looks like the hospitals people are just saying, I don't know, this isn't really an info letter. It's more of a, hey, if you want us to work with you, we will. So I don't, it's not really opposition.
Can you do that? So we can work off, all right, amendment adopted.
This is really interesting.
Yeah, it's fascinating. All right, so bills before you as amended, the motion is for a favorable with the amendment. Seconded, is everyone okay? All right, excellent. All right, well, Josh, do you have anything else left? Is that you? You're all good? Okay, got it. So we'll go to Heather, we'll go with Senate Bill 449.
Okay, Senate Bill 449. This bill increases the caps on the amount of compensatory damages that may be awarded to a complainant in an unlawful employment practice. The bill also increases from 2 years to 3 years the period of time for which the complainant may recover back pay in an unlawful employment practice.
Since you do this kind of stuff, what is unlawful employment practices? What are we typically talking about?
So the two bills, 449 and 451, are basically work together. So for unlawful employment practice, talking about like discrimination based on like a protected class or characteristics, so like race, ethnicity. And so what the piece that I know that Senator Castley was talking about before was that you're extending that statute of limitations to 3 years in the second bill that's coming up, because you have 2 years to file after an alleged unlawful employment practice, and then 3 years for harassment, which we've then, the bill that passed over last week changed the definition of sexual harassment. So that's essentially what it does. But the caps had not been adjusted since, I think it's been 2007. So we did this last year where initially the bill came in and just said no caps. This year we bumped it up and then tagged it, so it's kind of indexed at 5% every year so that you don't have to come back. And we thought that was a good compromise. Worked with Senator Castley on that. So that's essentially it.
Okay.
Limitations, you don't, the 2 to 3 isn't, it's a,
You have that window to file.
no, it says how much back pay you can recover. It doesn't change the statute, this 449 doesn't change the statute of limitations, it just says that you can only recover back pay up to 2 years. Currently, we changed it to 3 years.
Because 3 years is for the harassment. And so you wanted to peg it so that if you had a harassment claim, you could get 3 years of back pay.
Mm-hmm.
Oh, so Senator Castley, if you look at Senate Bill 451, and then if you look at page 2 of the bill, lines 1 through 5, that's where we're getting the 2 and the 3 years from. So 2 years after the alleged unlawful employment practice, and then you get 3 years if it's an alleged harassment.
You just want to give 3 years of back pay for the so you capture the harassment as well.
Yeah. I It's just one is a limitations period, the other just how far back
You can get back pay.
how you go back pay, and the reason, otherwise you wouldn't go back so far as you want to encourage people to step up and make the complaint and not just sit there.
Immediately, yeah.
Yeah.
I get it.
Yeah.
But sometimes, I mean, a lot of these things take time for people to bring them. I mean, it just takes time. Sure. Senator Lee wants to be a sponsor, Senator Carter wants to be a sponsor, Senator Hedelman wants to be a sponsor. No, there's
But
no,
now
no,
it's
no, there's just a
SWA.
sponsor amendment.
Now it's favorable with amendment. Yeah.
Do you want to do a roll call, or you just want to go down? Roll call? Okay, got it. So Cass is down, everyone else is okay? All right,
Wait, you said Cassidy.
Cass down. So now we'll just stick with Heather, that's your last one, is 451? Okay.
I'm just trying to pull it up. Okay, so Senate Bill 451 tolls the period of time during which a complaint may file a civil action that alleges unlawful employment practice while an administrative charge is pending. So currently, if an individual files an administrative charge, after 180 days have elapsed, they can terminate the administrative charge and file civilly. Under this bill, the individual would, if 180 days have passed or whenever, the time would just be tolled while the administrative charge is pending. And then at the conclusion of that, tolling period would end, and they could then, if they so choose, file a civil action. Cannot do both.
Discussion?
No, I don't have a problem with this. Yeah, because honestly, this was always a trap for the unwary.
Yeah.
Because they're in administrative proceeding, they think that they're abiding by the law, and they don't realize that, no, your limitations
Running.
period just expired, so.
And you can't do both, so you gotta satisfy the administrative process or
Yeah.
opt out after 180 days. All right, Senator Lee wants to move.
Motion is favorable with amendment.
Motion is favorable with an amendment, which is add a sponsor. Seconded, everyone's okay? Excellent. All right, now we'll go to Jamie. Let's just start from the top here with Senate Bill 31.
Senate Bill 31 sets forth the circumstances under which a custodian of records, in accordance with the PIA, must deny or allow inspection of recordings from body-worn digital recording devices worn by law enforcement officers. The bill does not apply to a public record that has been entered into evidence in a court proceeding, and also may not be construed to affect the discovery or evidentiary rights of a party to a civil suit or criminal prosecution. There are no amendments.
You're finally taking my advice. Asking like we did last year.
Say what? Yeah. All right, the motion's for a favorable. It's been seconded. Everyone's okay? Awesome. All right. We'll go to Senate Bill 83.
Senate Bill 83 prohibits a person from committing a violation of the prohibition on unauthorized access to computers and related material, either with the intent to interrupt or impair the functioning of a public safety answering point, or that does interrupt or impair the functioning of a public safety answering point. The bill imposes penalties of 5 years and a fine not exceeding $25,000 or both for somebody who commits a violation with the intent to interrupt, and 10 years and not exceeding $50,000 or both for a person who does interrupt the function of a public safety answering point. There is one amendment in your packet. It would basically take out the prohibition as it's drafted and would instead add it to a list. Let's see, going to page 2 of the reprint, it would add it to the list of organizations or entities that were specifically prohibited under the existing law. So currently, a person is prohibited from committing a violation of the computer abuse statute with the intent to interrupt or impair the functioning of state government, a service or device or system related to the production, transmission, delivery, or storage of electricity or natural gas, a service provided in the state by a public service company, healthcare facility, public school. So what this is doing below line 25 is just adding that to that list. The penalty can be found on page 3. So, person who violates C4, this is line 19, this ties it, just like everything else under the statute, to the amount of aggregate loss that's tied to it. So if the loss is $10,000 or more, the person's guilty of a felony, and on conviction is subject to imprisonment not exceeding 10 years, and a fine not exceeding $100,000. If it's less than $10,000, that goes down to 5 years and a fine not exceeding $25,000. C5, 2 years or $5,000, that's possession of ransomware.
The amendment, work on that. Senator Watson, go ahead.
Yeah, can somebody just define what a public safety at that point is, please? The PSAP? What's the definition of that?
For you,
I can't
While
put,
Jamie's getting the legal definition, it's a 911 system, is the colloquial.
that's it? It doesn't?
Right.
But it also includes a 311 system?
let me just double check on that for you.
We're creating that, are we?
No, that's not.
No, the system, like the emergency system, is that something we're recycling?
Be covered under current law. That's why she's adding this on, right?
Not specifically. I mean, generally interfering with
The government
computer
entity
system,
and computer system.
would be a violation of the law, but this steps up the penalties and puts them on par with, like, if you were to interfere with the system.
With the utility or something like that, okay.
So does it make sense, the amendment ties it into the loss, but amount of the loss, does it make sense to tie this penalty, I don't know how you would quantify the loss if you're interfering with the 911 system.
So, that's a legitimate question. There are other things in this list that share that issue. So like public schools are in this list.
Right.
And if someone
Hospitals.
didn't want their, D grade reported and went in, it's still all tied to this list. So there are other things in the list where the denial of service is not designed to steal money, but nonetheless to interfere, but we still keep it within this law structure.
It would just be in the 5 years,
Yeah.
it'd be in the lower you'd be the 5 years or 25. And that's what she's got in the bill, right? 5 and 25? She's got, for intentional, she's got 10 and 50.
A 911 call, right?
So pulling up the definition of a public safety answering point, it is a communications facility that's operated on a 24-hour basis and first receives 911 requests for emergency services in a 911 service area and, as appropriate, dispatches public safety services, transmits incident data to appropriate public safety agencies, or transfers 911 requests for emergency services, or transmits incident data to specified entities. So that would just be the 911 center.
Okay.
Station, or is this communications systems?
Definition applies to the facility itself. So the definition specifically says that it is a communications facility. So I guess what other, I'm not sure what other circumstance that could apply to that isn't the actual facility.
Like some sort of technological blocking, that's what I was thinking.
It's an interesting question because of how decentralized things are. I think that it would probably be read narrowly to apply to, anything that is an actual facility that falls within the definition of a public safety answering point. So if it was a service that was outside of that, but was related to what they did, I don't think that it would apply.
Okay. Although, I don't know, it says the interrupt or impair the functioning of.
Commit an act with the intent, well, that actually is a good point, because if you were going after, like, let's say Amazon has a cloud service that your 911 call center uses, you're right, you are violating the prohibition on interfering with computer devices, and no, actually, you're correct, Senator. It would be, even though not directly targeted at the 911 center, if your intent was still to impair their functioning, then, right, I think you're right, you'd have a violation.
Okay, thanks.
Discussion? All right, can we adopt the amendment? All right. Amendment is adopted. The bill's before you as amended. The motion is for a favorable with the amendment. It's been seconded. Is everyone okay? All right, we got Senator Lee with Senate Bill 326.
That's me, Senator. So this bill establishes that a violation of the prohibition on performing visual surveillance with pure intent, where the victim was a minor at the time of the offense and the person who conducted the surveillance was at least 4 years older than the victim, is a felony punishable by imprisonment of up to 10 years and/or a $5,000 maximum fine. There are two amendments in your voting packet. And the first amendment is amendment number 743723. And it expands the areas where, that fall under the definition of a private place. So if you're looking at page 2 of the reprint, it shows the current law. Private place means a room in which a person can be reasonably expected to fully or partially disrobe and has a reasonable expectation of privacy in. And then there's a list of currently 9 places that are covered under that. So this would expand that list to include a residence or another place of private use or accommodation. Currently, a place of public use or accommodation is included on that list.
What is that, what is another, what is private accommodation? Like
I'm
someone-
not-
I just don't know that. I don't know the answer. What's, I get what a public accommodation is, but what is a private accommodation?
Is that like a home, a residence?
So it would be,
But it's a residence or, go ahead,
I can guess,
yeah.
like a country club or some kind of,
Got like a,
something
yeah.
that's not open to the public.
got it. Like a membership place.
That would be my guess.
Even at a private club?
I don't know.
I'm not sure either.
I mean,
Because
think
you are
about the different
accommodating.
public accommodation laws at the federal level. I've never heard I've never heard it broken out like that.
Right. Because you're still,
Still a public,
you have members of the public who are coming to it. Now it's restricted, because they would have to be members of a private organization to use it, but.
right,
But
but still falls under the public accommodation laws.
It should, yeah.
I don't think certain clubs fall under public accommodation.
I think that's probably right. Is that it for this amendment?
Yes.
Senator Watson?
Right, just make sure I understand it. So this bill would not preclude a parent from placing a camera in a teenager's room to monitor activity, would it?
Well, it would be anywhere that a person could be reasonably expected to fully or partially disrobe, so that if that's a bedroom, then yeah.
It would preclude that, or,
Yeah, that would be prohibited.
well, then I got a problem with that. Because why would a parent not want to know what their child is doing? I know a lot of parents who put cameras all through their house to know what's going on when they're not there. And I did look up the definition of prurient. I understand what that means, but that's a part of it. You not only want to know what your child is doing sexually, maybe, but I'm just curious about that in a household that an adult owns. A child who's of age, who stays in that house, is a parent or a guardian going to have some problems if they just want to monitor what goes on under their roof.
Well, and to be clear, Senator, you would have to prove the intent piece. If their intent was prurient, it was motivated sexually, then yeah, I mean, that's 100% prohibited to put it in their own child's room. Without that, you'd have to meet both elements of it.
Well, let me dive into that definition one more time, because it's kind of weird when you talk about what a parent is interested in. So, a huge desire to look at some sexual activity, I guess, is prurient,
Let him finish up his.
right? But you have the desire to know what your child is doing sexually. Does that fall under the definition of prurient?
The interpretation for you, and just give me a moment, and I'll
Sure,
pull that
sure,
up
sure,
for you.
sure.
age, so I mean, one day, you're not a criminal, then the next day, because you left the camera up too long, and maybe your child felt, I see, yeah.
Cameras all installed throughout your house. I mean, just make it broad. What are the ramifications of that?
I'm gonna have to get back to you with a more definitive definition on prurient intent. Just going through Lexis on it, I'm not pulling anything specific up, but I did find a case that says that non-consensual video surveillance in a private place without prurient intent may constitute an unreasonable intrusion upon seclusion while not running afoul of this section. So there are cases that split the difference between with and without prurient intent.
Yeah, under the current law, as it is now, it's like anyone with prurient intent who, does the surveillance is right now guilty, and that applies to, no matter who the victim is, and you have that private place that's defined in here, it's a misdemeanor in 1 year, up to $2,000 fine, right? So this bill just extends it to a victim who was a minor at the time of the offense, and the person conducting surveillance is 4 years older than the victim.
Right, so,
And in this amendment that we're adding, adds the home as a residence. That's your concern, right? Because,
Well, so Senator, I think, sorry, God, you can answer, but just understanding, what is your interpretation or understanding of prurient intent is what he's trying to figure out, because.
right, so we're trying to find out what that element that is necessary to prevail.
What is your
under this
definition
law.
of prurient intent?
Well, that's what Jamie's looking for now.
But so what if so his scenario is if he's got a child that's there with another person and they're engaged in some sort of sexual activity, he wants to know if there's hanky-panking going on under his roof. So does that get slid into this prurient intent? Because he's just trying to.
He's recording them to post it on the internet. Or if he's recording them
I'm not sure it even goes that far, though. What if he's just
it.
interested to know what's happening sexually under his roof because he wants to prevent the hanky-panky? Does that third person slide that in and does it fall under the definition of a prurient intent?
I think that's different.
He's not trying to post it, he just wants to know.
Right, but I think that's different also if he wants to know because he's monitoring his daughter, if he wants to know because that is arousing to him. I mean, I think that's what we're getting at. That seems to me different from prurient intent.
And I'm looking for the legal definition because when I looked it up, it says having or encouraging an excessive interest in sexual matters. I have an interest in sexual matters under my roof when it comes to my kids.
About you.
Talking about this particular, but if you're talking about this, I think we need to be extremely careful.
Clear, right.
What I was saying is I think we need to be extremely careful because we had this situation when we were dealing with juveniles and sexting, and we got ourselves in a quagmire that we're still trying to get out. So, I mean, if we're going to do this, we just need to be real careful because if it's on the books, the prosecutors will use it.
Did you want to address their concerns? Do you need time to address their concerns?
I might check in with the AG on.
Yeah, why don't we do that? Because why don't we, you
prurient
don't want to
intent.
pass an imperfect bill either. And,
Senator Sindor brings up a good point.
Yeah, so let's check out those aspects, okay?
All right, so you have another forthcoming amendment, we're just gonna hold until we figure this one out first, and we'll
Yeah,
just hold the bill.
okay, sounds good. Yeah,
Do you want to roll through the other amendment? real
No,
quick?
no. And that is Senator Waldstreicher with Senate Bill 446.
So Senate Bill 446 prohibits the disclosure of the contents of any written or oral communication regarding a peer support counseling session by a peer support specialist or peer support participant, as defined in the bill. This applies to fire, rescue, or emergency medical service entities. There is one amendment. There was a requirement in the bill that the Behavioral Health Administration develop best practices for peer support counseling services. There was a suggestion at the bill hearing on this that MEMS, instead of BHA, be responsible for developing those best practices. And what the amendment would do is say that it's still with BHA, but BHA would consult with MEMS in developing those best practices.
Is that a compromise that makes everybody happy? Okay.
All right, so
Adopt the
can we motion to adopt the amendment? Everyone's fine? All right, now the bill's before you as amended, motions for a favorable. It's been with amendment, it's been seconded. All right, great. Just real quick, we'll probably vote on Tuesday. Just a heads up on, so we've heard a lot of the public safety bills that have come through and the transparency bills. We won't touch guns on Tuesday, but the transparency and some of the Baltimore-centric bills that came before us this past week, I'd like to vote on Tuesday. So we'll obviously be working through those in the days to come, but just wanted to heads up, we'll probably vote after after hearings on Tuesday. All right, with that, that's it.